The process to investigate the cases that have been brought against the suspended Chief Justice Gertrude Araba Esaaba Torkonoo has dominated discussions in the media space over the last few months, with people giving varied opinions and others questioning whether or not this is even worth pursuing and the kind of implications that this very case has on the judiciary and the integrity of it. Well, tonight we are here to have a conversation with the private legal practitioner Kwame Akuffo, who's handled a number of cases. I'm sure if you follow legal processes in Ghana, you would understand what I'm talking about. My name is Beatrice, and I want to say thank you so much for joining us today. Good evening to you, sir. Thank you for joining us, or agreeing to do this interview, I should say.
Thank you for having me.
Let me first get your thought on, like I just said, a number of people have been talking about the Chief Justice and what she's going through, and the fact that this is the first time we are having a sitting Chief Justice going through process to remove her, or perhaps after the investigation, exonerate her. How have you seen the process so far?
First and foremost, in answering this question, it's very important for all of us to notice and to make it very clear the very, very important point that this matter has raised a lot of partisan considerations, raised a lot of political divisions, and raised a lot of legal divisions. In answering your questions, I will be focused on what I do and I understand best. I'll look at it from the constitutional view in which I have a training. That is where I'll answer my questions from. Now, our constitution provides...
Before you answer that question,
yes,
you talk about partisan consideration as
yes,
well. Would you want to admit to that, in as much as this is legal, this is also very political?
Every issue that arises from a constitutional system has political undertones, but that's not the concern for me as a lawyer presently in answering your questions. I'm much more concerned in saying to you that the history of this republic has been replete with conflicts between the judicial branch of government and the executive. This is not the first time we've seen something like this. Under the 1960 Constitution, where Nkrumah had power to remove judges of the Superior Courts of Judicature, Nkrumah removed the Chief Justice without giving reason, because the Constitution gave him power so to do. Years down the line, our Constitution has grown to a certain level where the President, to be able to remove a Chief Justice on the basis of a petition, has to go through processes. Unfortunately for us, this is the first time it is happening, and therefore there are varied considerations and varied attentions coming from all quarters. There's a school of thought that because she gives certain rulings, some political divide is against her. There's another school of thought which thinks that this is a purely constitutional matter. So far as I'm concerned, when citizens of the Republic feel aggrieved and ask for the Chief Justice to be removed, they have only one method to go through, and that is an Article 146 consideration. That Article 146 consideration can never be immune from imperfections. And that's why we're having this debate.
So in as much as we have grown, per your own statement,
that's
from
correct.
The 1960 Constitution,
yes,
to now, you
yes,
still believe that the current 1992 Constitution, yes, we've grown, could still have issues?
Every constitution has imperfections, and that's why the robust nature of a democratic system allows the constitution or institutions set up under the constitution to be tested effectively in courts.
And I'll let you continue with your understanding of the Article 146 that we are certainly going to go into,
right,
and how you think it is being tested now, because this is the first time we are using it.
Right.
Let me take you back to a statement you made earlier.
Yes.
That perhaps there are a number of schools of thoughts,
yes,
that say that perhaps she's going through this because of rulings that she's delivered on certain cases.
correct.
Where do you stand on those?
I beg no opinion on that.
Why?
Because you cannot stop people from thinking the way they want to think. At the end of the day, you have to approach matters in an objective way. I cannot, for purposes of the law, be concerned about the subjective thoughts of people when the objective standard of an Article 146 procedure is prevalent.
So, for instance,
yes,
one of the things that, or one of the main cases that a lot of people refer to, has to do with Parliament. And the fact that the Speaker of the House said that 4 individuals had said they were not interested in the party they originally belonged to.
Yes.
And per the Constitution, the Speaker interpreted it or I shouldn't say he interpreted, because he doesn't have the power to interpret the constitution. The judiciary, he took the position. Yes, he took the position that those individuals had decided to let go of their seats, and therefore there had to be exactly, the seats were vacant, and the Chief Justice decided to come in and say that, well, the Constitution gave the Supreme Court the power to interpret, and people felt that it was a direct confrontation of the judiciary and a clear interference of another arm of government. Whilst when the LGBTQ bill was passed, she didn't do anything about it when the Attorney General wrote to the Clerk of Parliament that don't even bring it to the presidency.
The comparatives are not necessarily an ingredient for impeachment. Those comparatives are not necessarily an ingredient for impeachment. We go to court on every occasion and we get rulings against us. I disagree with the Chief Justice in respect of a ruling when they gave, there was an ex parte application, and the application was granted to run till the end of the case. I disagreed with her. But those are not ingredients for impeachment, because judges have the power to go right and have the power to go wrong. We go to court sometimes, we put forward very good cases, we lose. You may complain in the comfort of your office, but that does not necessarily become an ingredient for an impeachment process.
So on the Parliament one?
On the Parliament one, with respect to the Speaker back when
yes,
the Chief Justice took a position in court, which I disagreed with, especially in respect of the application for injunction. I disagree that it was held ex parte. I thought there was substantial time for people to have been put on notice. I thought that it was unnecessary for the court to be engaged in an existing confrontation with Parliament, especially as we approached an election period. It gave us very, very tense situation to the environment, the political environment at that time. But that is not to say that these are ingredients for impeachment.
So you agreed that it was an interference?
I wouldn't say it was an interference. It was a constitutional interpretation which did not favor the parliamentary branch of government. I wouldn't call it an interference. Otherwise, persons who do not disagree with the decision to form an Attorney General or J.H. Mensah will call it an interference. Ever since the days of Marbury and Madison, we've come to understand that the Supreme Court is the court vested with power to interpret matters, acts, and everything that comes from Parliament. So it's not an interference. But back to your question as to how people view this, I take the firm position that persons who are aggrieved and want the Chief Justice removed, irrespective of their motivations, will have to trigger an Article 146 proceeding. It is how those who look at the proceeding and those who handle the proceeding, that is what matters for me.
And I would want to proceed quickly to the Article 146, but I still want to get your final thoughts, asking you one more time, that you disagreed with perhaps how she went about the Parliament thing. So would you say that she was wrong?
As a matter of fact, I do not like to say to a learned person or a person that the person was wrong, especially when they are my elders and betters. I will say that the appreciation of the position was not consistent with the settled practice. It's quite a bold and audacious statement to say to your elders and betters that they are wrong. It is much more polite from where I come from to say that the appreciation of the Lord was not in accordance with the settled practice. That's the way we behave, because sometimes your thinking or your dissenting thinking can be the intelligence of a future day. So I do not like to condemn other legal work as being wrong.
Having made that point, and once again, just before I go to the interpretation, would you say there are those who think that, and that's something that you've said, that there are schools of thoughts regarding how she's handled matters, and others are concluding that perhaps what we're seeing now, she brought them upon herself with her own actions and inactions?
I don't believe in that she's brought anything upon herself. I think that those who have brought the petitions have their own reasons for bringing a petition. Every day in and out as we walk the streets of this republic, people make complaints against us, sometimes on their lips, sometimes on the soft part of their minds. If they had a venue to ventilate this, they will bring it against you. When a judge sits and gives decisions, she has rendered the decision. As to how you decide to look at it, it's not a matter of the judge bringing it upon herself or himself, that judges will be caged. But as I keep on saying to you, those are not the things. Let me just move very straightforward to a point. We've had this constitution for 25 years and more, if not 33 years for that matter.
From 1993?
25 plus 33 is out, 33 years. Now, we have a situation where I would have thought that by now, and perhaps this case should teach us a lesson, that there's a need for a constitutional instrument to regulate the removal of the Chief Justice, so that we know what pertains in the procedure. I'll give you an example. When it comes to the removal of the president under the Constitution, for example, all the persons, for example, that are constituted by the Chief Justice, so as the formation of the prima facie case before the recommendation to Parliament, are lawyers, are people learned in the law before they become judges. Unfortunately, our Constitution says that the removal of the Chief Justice is by 2 justices of the Superior Court of Judicature, i.e. the Supreme Court, and then 3 non-lawyers. Now, these persons are not learned in the law. So we have such a serious situation where the judges who are sitting on this have to grapple with the fact that the 3 of them, their decision can trump or overturn the decision of the 2 learned judges. That's a critical omission for me. That's a crucial deficit for me in our constitutional tapestry. That you appear before a committee where the leaders of it is chaired by a lawyer who has become a judge at that. Judge who has been there delivering fine opinions. And then suddenly that judge now perhaps has to subsume his thoughts or his independence of thought to a 3-member team which is not learned in the law. That's a crucial thing for me for purposes of this impeachment proceeding. And it's dangerous for our democracy because you can't expect, for example, cabinets to review the work of a doctor.
Okay, so let me read again to you Article 146, I beg your pardon, which we're dealing with now. And it's up to, I believe, 9. Oh, no, it's up to 11.
Yes.
And I think what we are interested in starts from 6. So I'll read from 6, which says, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers.
Yes.
7 says the committee appointed under clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. 8. All proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. 9. The President shall in each case act in accordance with the recommendations of the committee. 10. Where a petition has been referred to a committee under this article, the President may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State by warrant signed by him, suspend the Chief Justice, which has been done in this case already. In the case of any other justice of a superior court or of a chairman of a regional tribunal acting in accordance with the advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal. And then 11, the President may at any time revoke a suspension under this article. I want to go back to 6 because you said and you emphasized the fact that there are members, 3 individuals who are not lawyers and may not necessarily appreciate the case that we're dealing with. Right. But if you read 6, it says where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State. The Council of State, we know the composition of the Council of State. We have former Chief Justices on the Council of State. We have senior police officers. Currently, we even do have the former IGP Mohammed Al-Hassan on it, and a few other people who have occupied very important positions. So it presupposes that it is not just about these individuals you mentioned who may not necessarily appreciate the law or the case. You have prominent people the President first and foremost would have consulted with before going through the rest of the process. So why should you have a problem?
I do have a problem, and all of us should have a problem. Because the first part of the President's making a determination that the committee has to be set up, a prima facie case has been made, and the committee has to be set up. The Council of State. I am talking about a committee, the 5-man committee, where only 2 of them are lawyers. Let me make this very clear. For purposes of admissibility of evidence, it's a question of law. Admissibility of evidence for any proceedings, especially a quasi-judicial body which decisions affect the liberties of an individual, it's a question of law. How do the 3 members of the committee appreciate the legal aspects of this, so that if, with respect, Justice Palman says that this document is not admissible, Justice Esaaba says it's not admissible, do the 3 then outvote them? Is that what we're doing? This constitution was written in 1992. I am not sure that the framers will have done so today, because it is quite clear that in dealing with a matter as serious as this, you cannot have a situation where the people who are not learned in the law are more than those who are learned in the law. It cannot be a proper representation.
I'm happy you talk about the fact that this has been there for at least 25 years and more.
That's right.
You've been a lawyer as well for that long.
That's right.
I mean, yourself and other lawyers, if indeed, yes, it wasn't applied,
yes,
we could have still spoken about it.
I agree with you. I did not. I am speaking about it now.
Why now?
Because the issue has now come up for consideration. I regret I didn't see this point earlier. I regret others may not have seen it, or others have seen it and have not spoken about it, but it was never too late to speak about it. And I think that the consideration of this in the constitutional tapestry is not proper.
Doesn't this give the impression that other people have, for instance, that it looks like we're getting some lawyers wanting to, paint a different picture, that the president should just, let this thing go and just let things be as they should be? And I'm sure you followed the GBA that program where the president spoke and said that she felt like this was more vindictiveness than going through a legal process.
I cannot speak to the president of the Bar Association's position. I don't speak for the Bar
You don't
Association.
agree with her?
I am slow to come to that consideration, because measuring vindictiveness is not an objective standard. I like to be objective. It's quite difficult to measure somebody's vindictiveness, especially when the president is following the constitutional steps. It's the product of that constitutional process that you can begin to assess it. At this stage, because comments have been made, for example, that the Chief Justice should be restored to a position.
And that's one of the points that she made.
The practical implications of it are onerous. In the first place, if the Chief Justice is restored to a position, how does the Chief Justice then preside over the panels and panel the court, and then turn back and then appear before her juniors at the impeachment hearing? It's untidy. It's awfully burdensome. It's not proper. Practically, it doesn't work out that way.
So suspension should be in place?
I'm not saying suspension should be in place. I would have thought that under such circumstances, perhaps the Chief Justice will have taken a leave of absence in that interim period. But it's a constitutional process, so that in future, perhaps when it comes up, the Chief Justice will be given the option to, for example, go on a leave of absence. I say this: if the Chief Justice still remains at post, because she is head of the system, it will mean that decisions and matters affecting her will come back to her. And if the Chief Justice is an active complainant, as we have in this situation, and then she has to come and preside over matters affecting her, because then she'll say that as a matter of constitutional necessity, she has the right to sit on cases, it will jeopardize the trust that people have in the judicial system. So it is better for the Chief Justice to be removed from the arena of conflict at this stage. She could have been on a leave of absence,
which she didn't do.
Well, I do not know whether she was given an opportunity to do, so I cannot speak to that. I will be very factual. I will not assume. The point at stake is that, insofar as I'm concerned, it will be a bit tedious, impractical, to have the Chief Justice come back presently to superintend who? To superintend the justices who have ruled against her now, and then to go back and then empanel with justices to sit in cases affecting her. Will she sit on cases affecting her and say that because of the constitutional necessity she's Chief Justice, she can sit? It will bring a lot of uproar and confusion in the constitutional system.
But would you like to appeal to the conscience of the president? Because I read the 11,
yes,
which said that the president at any time can choose to revoke the suspension.
I am sure that the president at any time can choose to revoke the suspension. And perhaps that is a practical arrangement where the Chief Justice is on a leave of absence. But the point at stake is, what is the benefit of the Chief Justice, especially now that she's an active complainant, an active litigant, coming back to sit upstairs? It's quite difficult. Practically, it will not work. It will throw the court into confusion.
So you say that she should have taken a leave of absence?
I'm saying that one of the options which could have been open to her was for her to take a leave of absence. But the Chief Justice cannot be actively carrying out her duties when impeachment proceedings are underway, because if she complains about the process and decides, for example, that she wants to ventilate that grievance in a court of law, it means that she files the process, she empanels the bench, and then she can also decide to sit on her own case. It will leave the sense that justice is not being done properly.
Now, she didn't, or the leave of absence wasn't done, and
Yes.
we had the president using his power to suspend her provisions in Article 146.
Right.
So whether it was by leave of absence or the president using his power,
She's absent.
she's absent.
Right.
Others feel that perhaps she should have resigned, having made the point that if there was the option for her to take the leave of absence, she should have taken advantage of it. Would you then agree with her that it is not an option to resign in the midst of this?
Well, that's a very important question. To resign is to concede that you will not fight the issue. And generations that will come after us will say that you knew that you couldn't fight the charges made against her. That's why she bowed out honorably. And therefore, her position that she will fight till the last drop of sweat on the battlefield is respectable. She's entitled to fight it till the end. She's entitled to fight it to the end. It is a restoration. I am not too sure that even the Chief Justice wants to be restored at this stage, especially when she's in active conflict with the court itself. I'm not too sure that the Chief Justice is wishing for that. I do not know what informed the bar to speak that way, but that's the bar that has spoken. I'm a member of the bar.
No, I'm actually talking about she herself. I mean,
Chief
that,
Justice
yes,
asking for
there's
restoration?
no, the press conference she held recently.
Yes.
I'm sure you remember she said that people had appealed to her that
She should
it's
resign.
not worth it. She should just resign. And she said she won't resign because, and she gave the same explanation you just gave that.
But there are ongoing proceedings as well. And she's not reached the statutory retiring age. So she cannot even resign. There are ongoing proceedings. And because there are ongoing proceedings, she has to go through it. She doesn't have the option of even a resignation constitutionally.
Was it a good decision for her to have held that press conference?
When you're asking whether it's a good decision, I don't like to answer things like a Presbyterian pastor. I'll speak to you like a lawyer. The Constitution says that the proceedings must be held in camera.
Exactly.
Things that the Lordship, the Chief Justice, the Ladyship of Justice Torkonoo talks about is a word against the committee. We do not know what happens in the committee room. But I will say that because the Constitution speaks about in-camera proceedings, and that body is a quasi-judicial body, persons who are aggrieved by it should be bringing applications to the High Court by way of judicial review to contest it. I do not think that it can be a discussion of it by way of press conferences. I don't think so.
She shouldn't have held that press
I'm not going to pass a value judgment on her ladyship. I'm saying to you, let me just make my point. I'm saying to you, I'm not going to put a value judgment on the Chief Justice's actions, but I'm going to say to you, as a lawyer, that the remedy for a person who is aggrieved with things happening in the committee is to go to court and ventilate it by way of judicial review, because it's a quasi-judicial body. You may choose to draw the inferences, but you will not have it from my left.
The Article 146, which I've read entirely to you,
Yes.
is saying that everything should be done in camera, which you've admitted.
You see?
Yes, so if everything should be done in camera, and you've gone ahead to even read petitions that the public supposedly doesn't know about it, then it looks like there's a breach of that article, again, that very clause that says that everything should be in camera that you know about, and yet you come out to read what is supposed to be in camera, which is why I'm asking you that question.
Let me get back to this point. There's a complete erosion of the privacy of the proceedings on both sides. It's a complete erosion. The Republic and its citizenry are very much aware of the content of what happens in there, insofar as the petitions are concerned. The question which arises for consideration is what is in camera today. In 1992, we didn't have all this tech we have today. The issue of in-camera proceedings has become virtually constitutionally non-existent. Because I've asked the question, if indeed the framers wanted us to have such a star chamber proceeding, so in camera, why do they tell us the names of the people who are presiding? Has anybody ever asked himself that question?
So it's just on paper, not in practice.
I too think so. That is quite difficult because the Constitution has a spirit of openness. If it is in camera, then all that we are required to know is that the president has met the threshold and the requirement of appointing people who are justices of the court and three non-lawyers. But they need not tell us the names. Because once you mention the names, the in-camera aspect of the proceedings is sufficiently caved in. so we know that these people are presiding. So what is in camera? I think that the Constitution itself is not properly aligned on this ground. The President of the Republic, when he's being removed by the parliamentary processes, is in the open, albeit by secret ballot, but it's in the open. Why is the Chief Justice own, who is vetted in public? And let me make this point very clear. During the vetting of a Chief Justice, for the person for the office of the Chief Justice, some of the questions which are asked that individual are questions which can serve as disqualifying factors to ascend the office. Therefore, during your vetting period, you are virtually going through an attendance session in the form that you are being admitted to be Chief Justice. In the same way, some questions can be in the form of an anti-impeachment, reverse impeachment process, because those questions can disqualify you. The answers to those questions can disqualify you. We do it in the open. Why did the framers choose to have a situation where they will vet an individual in public for such a high office, but remove the individual in the dark? It's not very constitutionally aligned. We vote in the president in the open, and the tail end of the process of the removal of the president is done in parliament.
So what do we need to do before I even proceed about Article 146? I know you've spoken about the need for us to have a constitutional instrument,
Yes.
I believe, to supplement what is in the
That is
Constitution.
correct.
Aside from that, what do you want to be done to reflect perhaps the modern challenges that we have when it comes to implementing some of these articles?
Very well. For example, we know that courts of the land, when the panel is 5 throughout the Constitution, we know very well when it's an odd number, it's by a majority. But the committee that presides over an impeachment hearing is not a court. There's no part of the Constitution which tells us whether the 3 members, if they are the majority, will overrun the voices of the 2 learned people on the committee. We do not know whether the recommendation should be unanimous. We do not know. We do not know whether it should be by a simple majority. We do not know whether it should be by an 80% majority. And I think a constitutional instrument and constitutional reform should look at this issue critically, because the committee which has been set up in presenting its recommendation, as the Constitution says, what recommendation? Is it a majority recommendation, or we are just assuming that just like the courts, it's a majority? No.
The opinion you're sharing with us, have you already shared with the committee to look into?
No, I have not.
Do you intend to?
Well, perhaps now that we've spoken about it, it will come to attention because you have a very broad outlook. But the point at stake is that, and those who are working with it are burdened by this legacy. They have had no hand in this, and this has come up. And constitutional imperfections always happen when the process is new. And then we learn from the mistakes and go on and do it in a better way. So these are some of the imperfections that I see.
These are some of the imperfections that you see. Others also argue that perhaps we had the Chief Justice coming out to share, as it were, her side of the story, because the narrative is that she's not being treated fairly. Do you think she's not being treated fairly?
I cannot speak to that because it's just a word. I have not heard from the committee. The only way that we can hear from the committee is that because this is an in-camera hearing, the appropriate constitutional thing for any person to do who is aggrieved is to go to court by way of judicial review and challenge it. If it gets there and we think that national security matters are up there, then by virtue of Article 135, the High Court can make a reference to the Supreme Court for that part to be determined. I would rather prefer that the institutions under the constitutional system are used for purposes of harmonizing and harnessing our constitutional system rather than press conferences.
But she already said that she felt that the processes as we have them are just being used as a cover-up to remove her because, I mean, she feels like there's a political witch hunt here, which, well, obviously, I'm sure you're aware that after her press conference, the government immediately responded to that. And you, when we started this conversation, actually said that there are political undertones in a number of cases. So would you agree with her in that case that perhaps, you know, she is seeing the political undertones that you mentioned earlier?
Let me put this in 2 ways. Every constitutional court, i.e. the Supreme Court all over the world, is always afflicted with political considerations because the judges are human beings. If you look at the American Supreme Court, for example, these days they've had all the time 6-3 decisions because the Republican candidates who have gone to the bench have always gone the very conservative way in favor of Donald Trump, while the three Sotomayor and others have gone the liberal way. So there's no court which is immune from partisan and political thinking. The question is that it comes out in the form of a judgment. As lawyers, and the Chief Justice well knows that, when we come to court and your idea of a constitutional interpretation does not favor the judge's orientation of where the constitutional democracy should be like, you're likely not to make ground. And therefore, when she speaks of political overtones, she will know, having been a judge, that there are cases which have come before her in which the public and even the bench approached it from a certain political orientation. Because if a judge is a liberal, that judge will interpret provisions of the Constitution differently vis-a-vis a judge who is a conservative. But it doesn't take away the fact that under the Constitution, there are institutions which are to be used to protect the in-camera proceeding. Until the in-camera proceeding is taken out from the Constitution, irrespective of the weaknesses of it, until it is taken out, as lawyers and persons working with the law, we are obliged to respect it. The in-camera proceeding does not stop the Chief Justice from bringing an action in the High Court to complain.
So you're saying that your understanding of what the Chief Justice said earlier at that press conference is that you think she's seen enough cases for her to conclude that there could be political indications or undertones. But in this case, when she was talking, she didn't refer to any case she's seen. She referred to her case. She was specific.
Let me be clear on one point. The Chief Justice has been a judge. She's still a judge. She's had cases, she's had people say this case is political. Every case which involves the interpretation of the Constitution has political twinnings to it.
Do you think this case, the current government is using politics and using the Constitution as a cover-up just to clear her?
It is not. You see, for example, if you do not like me and you see me falling foul of the law, or you think you want to bring the law against me, I cannot be here to say because you don't like me, you're using the law against me. We lawyers go to court all the time. You may have a very solid case. The judges disagree with you. We leave sometimes a mumble and say, oh, I don't think the judge likes me. I don't think the judge likes me. But that is not good enough. You have to look at the judgment, and if you are grieved, you go to the court and appeal against it.
I'm asking for your opinion.
I'm telling you my opinion. I'm telling you my opinion.
I thought I would get a yes or no.
No, I can't give you a yes or no because it's a factual circumstance. So I have to explain to you by way of examples. So it is not that easy for you to just conclude that something is politically tainted. At the end of the day, whether it's politically tainted or not, levers under the Constitution have been activated. Her press conference was very satisfactory to some people because they said, oh, is this what is going on? But I'm saying that if this is what is going on, let's test it by way of judicial review. It is not a press conference which is the solution. I mean, with all due respect to the Chief Justice, I can't imagine that if I was appearing before her, and I say this with the greatest of deference to her, and midway through the proceedings, before she would give a judgment, I held a press conference and complained about how she was doing the case, she'd be terribly upset. She'll be terribly upset. She will say to me, Mr. Akuffo, if you do not like what we're doing, you come by way of an order to set aside, because that's our training, that is our teaching. We are not trained to hold press conferences when judicial processes do not favor us, unless it is at the tail end. So the appropriate thing to do is to go to the court by way of a judicial review and challenge the committee. Some people, for example, talk about the committee's, the rules regulating the committee. The Chief Justice has complained about it and thinks that other provisions should be used. It's a legitimate question to ask whether the committee on its own, a quasi-judicial body, can adopt the High Court rules. It is important for the Chief Justice to go to the High Court and ventilate that so that we will all learn.
So obviously,
but we cannot learn by way of press conferences.
Obviously, you would have preferred that the Chief Justice had used the High Court instead of using the press conference. But I still haven't got my answer as to whether or not, based on the interpretation of how things are going, by the Chief Justice, her interpretation, she feels that this is more political and the Constitution is only being used as a cover-up. And I'm saying that having seen what you've seen and heard what you've heard, would you say that perhaps indeed, as you said earlier, that in every case there are political undertones? In her case as well,
Yes.
the government may be using politics and just to clear her and using the constitution as a cover-up.
I have made it very clear. Every matter that has constitutional underpinnings is anchored on political orientation. Politicians in the space, in trying to angle for power and security, have always used the constitution.
So the government is using just the constitution to clear her because they want to.
No. Let me just make this very clear. Irrespective of the motivations of a person, you cannot necessarily demean a constitutional process because somebody has some political bad blood against you. Because you cannot stop even a person who likes you from bringing a constitutional grievance against you via Article 146. It is for us as lawyers to see whether the product of this process can stand the test of time or can be scrutinized constitutionally. The Chief Justice has a complaint, many of them. I say to you, I say to everybody, the way to go on this is not by way of press conferences. It is by way of ventilating, by way of a judicial review, because that body that she's appearing before is not a high court.
It's a press.
No, it's not a high court. It's a quasi judicial body, and it can be corrected by orders from the high court. And she knows that. And that is what I expect us to do. So I do not fancy press conferences. But then you have to understand, when you are personally involved in a matter, you may forget that you are what you are because you get emotionally involved. And it is easy for those of us who are not in the pot to sit back and advise. But the appropriate thing to do, with respect and with great deference, is that we should test these things by way of judiciary.
So her press conference was an emotional response instead of
you say so. You pick up
well,
words
I'm just
from me,
picking words
then you put
from
an adjective on it, and then you amplify it for sound bites. I disagree with you. My point at stake is this: I will not place a value judgment on my elders and betters. I will never do that. God forbid. I will speak to the law. I will speak to the options. The options open to the Chief Justice, and the proper one is to go by way of judicial review.
I'm just reframing your words in my words.
You will not have me allow you to reframe my words or rephrase them, because every grammatical thing that you do has consequences for sound bites. I will not put a value judgment on the Chief Justice's conduct.
Having made that point,
yes,
what's happening? Is it good or bad for the judiciary, the integrity of the judiciary, and our democracy moving forward?
You'd like to put a lot of value on legal issues, but let me answer the question. It is essentially useful for the institutions of governance to be tested from time to time. It's essentially useful in that the robustness and the strength of the system, for example, if you look at Justice Kulende's judgment, he said, for example, in refusing the injunction, that courts have rarely granted injunctions against executive orders unless there's a clear breach of a constitutional provision, and that they rather prefer to waste post facto judgment to be able to speak. And that has been the prevailing practice. The court will hardly, for example, in constitutional matters, grant an injunction midway unless it is quite clear. Now, this is a situation where the injunction applications, for example, were brought at the very beginning of the proceedings. And therefore, the court took the position that it could not injunct at that stage. The issues must be guided on the basis of what the law says and not what is good or bad. Because when a decision goes against a lawyer, he says it's bad. When it goes against him, it's good. But objectively, what then is the law?
The Chief Justice has complained about the venue for this process, and even in her press conference referred to the murder of judges, and the government didn't take it lightly that why you kind of comparing apples with oranges. These are my words. That's not what the government used. Do you think that she should be granted that the venue should be changed so she feels a bit more at ease?
I do not know the venue. The government came to speak about the venue subsequently. We know from the SIB reports, that's what I know from the SIB report, that in October 1982, I think Amedekao and Chikata Alechov had a meeting opposite Edu Lodge. I do not know who was resident of Edu Lodge. But I think that the issue of a venue causing an emotional pain or burden to an individual is something that can easily be rectified behind the scenes. I'm quite sure that these matters, if they're raised through the appropriate channels, will certainly be addressed.
Well, the Chief Justice has raised it through a press conference. Might not necessarily be the appropriate venue, but should it be heeded?
I should think so, that if it's something that causes the person a traumatic reliving of a traumatic experience, it should be something that can be addressed. Government has several avenues. I do not know whether the rectification of same or the correction of the complaint of same had been made to the committee before, or it was made first time by way of the press conference. But I think it's a matter that can easily be resolved at the back doors.
So that's one aspect. The other aspect has to do with his family and access to people that she feels comfortable to be around.
It's a word against the committee. The committee is not speaking on that. I can't speak to that. I can't get into assumptions.
Let me ask you, just moving a little away from the Chief Justice and having to do with the appointment of justices to the Supreme Court. I think that for many years we've had debate on capping and the need for us to ensure that we are not loading our court, as it were, because every president comes and appoints because the Constitution gives them the power to do so. Where do you stand on this?
It's a very tricky issue. A few years ago, Joe Biden, President of the United States of America, was looking to get Congress so that he could pass and put more judges on the bench, more than the 9. Because so far as he was concerned, the court had tilted in a direction which had taken away illegitimacy as a constitutional organ which was holding the balance evenly. That thinking of putting people on the bench is something that leaders who believe that the court is moving away and just shifting towards a particular place requires it to be shored up, and in response, therefore, we send people to the bench. 7 fine minds have been sent to the bench.
Adding to 20, right?
Yes. Unfortunately, by virtue of the political discussion that we have, these persons are now being tainted as yes men, which is unfortunate because that's the consideration. And that's why I say that every constitutional issue comes with a political baggage. But fine minds have been sent. But there is a problem because of the constitutional, the political discussion which takes place. And that's the danger when we introduce politics into an objective consideration.
Do you believe in the cleansing of the judiciary? Because people say the appointment of...
Can I finish answering the question before you go to the next one? Thank you very much. Now, you have a situation where they've put 7 new ones there. I heard an Islamic cleric say that the president had said during his campaign time that he was the child, the courts were being packed and he's come to appoint 7. So that political thinking, just the same way, is affecting this appointment. In the same way, political thinking on the street is affecting the impeachment process. But at the end of the day, the framework that didn't put a cap. The discretion of the presidency of the executive will only be measured by the work and the perception that people see of the bench. So we can shout ourselves hoarse, but if those in charge think that the court is not serving the needs of their political agenda, we will see a situation where they will think that they need minds to restore the balance of constitutional legitimacy on the bench. So it's a very tricky question, but unfortunately, the people who suffer the most at the end of the day are the judges who are sent there on the merits of their minds, but people begin to perceive them in a certain way, which is really unfortunate.
So you've just made that point there about the perception that perhaps the people there may not favor me. So do you think that's what we're doing as a country? Because every president comes and wants to appoint. Is that what we're doing as a country?
Every president has appointed people to the Supreme Court on the basis of they looking his or his way. It's just the same over the world.
So you believe in the cleansing of the judiciary?
When you say cleansing, what do you mean?
Which is the point you just made.
It's a very dangerous word to use, especially because we've just come out of Martyrs' Day. To use cleansing, it sounds very revolutionary.
Okay, so that's not murder and that's not... Yes, that's not martyrs.
You are talking of putting the judiciary... I think that the judiciary is doing its best within the circumstances. You see, we go to court every day. We suffer losses. We gain wins. But you don't bastardize an institution because of some of the imperfections that come. The judges who sit in the courts work under immense pressure. They are not staffed with all the law clerks which are available to judges in the United States of America. There's a heavy caseload, administrative bureaucracies. So much happens to these judges. So the imperfections in our system should not be taken as the sole ingredient in measuring the worth of those.
If you say in our system, you mean locally?
Not just locally. The imperfections in any judicial system should not be used as the sole ingredient in measuring the worth of those who command the judicial branch of the republic. They work under intense pressure, and we should give them a bit of credit for that.
Let me try to understand you better. You're saying that irrespective of the perception that there could be political appointments, Ghanaians and people who are interested in legal stuff should rise above the supposed political perception and believe that those judges, even if they were selected because of political motivations, we should believe that they would rise above those. That's what you're
Judges have been appointed by presidents and have turned around to rule against them. The judges take an oath. The judges take an oath to do right by all manner of men. And therefore, to a substantial degree, a judge cannot look at A to B and say it's D. Judges have a duty to perform under the Constitution. And to a very large extent, it does not matter who appoints a judge. And I will say this to you. Judges come to the bench with a consideration and orientation of the law. That orientation may be a bag of a bit of politics, a bit of a bag of the environment from which they've come. A judge coming from a Galamsey area is likely to look at a tort action against a Galamsey company in a very different way. A judge coming from a very politically charged environment is likely to look at matters in a different way. And therefore, judges will always have that political landscape of he was appointed by Akufo-Addo, he was appointed by Rawlings, he was appointed by Kufuor. It will always be there. But at the end of the day, judges stand up to the Constitution and perform their duties.
If that was the case, why the interest in presidents to want to appoint judges? Why that? Real interest in appointing judges, if that was the case, aside from filling vacancies.
Because they believe that the judges will see things their way. But I must say to you, judges get onto the bench and disappoint people. All the judges who voted against Justice Torkonoo recently, how many of them were appointed by John Mahama, with respect? Several of them were appointed by Akufo-Addo. Torkonoo herself, with respect, her ladyship was appointed by Akufo-Addo. So what has changed? So you have to always look at this matter in a very objective way. You have to rise above that thinking, which is, oh, this man appointed him. Justice Tanko was appointed by President Akufo-Addo. But he was writing his ruling against a judge or a chief justice nominated and approved by a parliament under Akufo-Addo. So you cannot say that because a judge has been appointed by a particular president, that judge will necessarily do the biddings of that government.
Having made that point,
yes,
the concern still stands that we are loading our courts with too many justices. Do you think there should be a cap?
Do I think that there should be a cap? That there should be a cap is a question of facts.
And at
what
which
is
number?
The workload that we have presently? In America, there's only one Supreme Court which sits in Washington.
But that is the federal Supreme Court.
Yeah, I'm going to make a point to you. In the United States, for your case to go to the Supreme Court, you need leave for the courts to even take your case. In this republic, under our constitution, it's only few cases coming from the circuit court, goes to the Court of Appeal, or which you need leave, or cases coming from the Court of Appeal into local matters, which you need leave. There is a substantial number of appeals coming up to the court. I don't think it's about capping. The proper thing to do is to put competent and effective persons on the bench to deliver. But I don't think we should constrain ourselves with capping, because that can be a very dangerous issue depending on the circumstance. Let me give you an example in the Chachishikata case. When the bench, they had to then quickly find another judge and put there because the court was split. If you begin to cap and circumstances arise where there's need for fresh minds to sit on the matter, there'll be a problem that the new people who have been put there are people who are politically tainted. I think that the framers, in putting that provision there, put it there and left it to the good sense of the presidency to do what is needful. Ghanaians have now come around to think that the court is being overloaded. What then should be done? What number should we cap it at? 11, 13, or 16? Should every region have a representative? Many years ago, when the regions were 9, you will find out that every region had a representative on the bench. If we have to go for capping, I think the 16 should be a good number to represent every region having a representative. and not much more than that.
And not much more than that. Because I
Yes.
was going to ask you whether we should go on and on, since you said that it wasn't a matter of capping, but it's a matter of competence. And I was going to refer
that if we have to go for capping,
it has to
we should be looking at it at a regional basis, so that we don't have 6 people from Greater Accra without a consideration from people from other regions. But I think that the court should be staffed in a way that reflects a regional representation vis-a-vis a capping issue. Once you do the regional representation, you're going to have 16 people to man the court. We can't keep on going up to 20, we can't go to 30. It would be ridiculous.
Let me ask you your final words.
Please do.
Your final words.
Final words.
Yes, if you have any final
We've had a
thoughts.
constitution that has worked for us on many occasions. We've had a constitution that has been tested. One of the biggest examples was just prior to election, when the Speaker and the Chief Justice were at it, or the Supreme Court and the Chief Justice were at it, the Supreme Court and the Parliament were at it in these matters. I think that as Ghanaians, we should have faith in our constitutional system and look to see the system working. And all of us should be energized to ensure that the system works. That's the appropriate thing to do.
All right, thank you so much. And that will be it for our conversation. And you just watched right there, if you're just joining us, that legal conversation with private legal practitioner, lawyer Kwame Akuffo. And of course, we've talked about varied issues, the ongoing investigations against the suspended Chief Justice Gertrude Torkonoo. And we've also gone into, or we went into, the judiciary and the number of judges that are being appointed. Join us again next time. Thank you.